Landlords, just another PSA. If you don't know how to fill out a 3-day notice to pay rent or quit, you have no business serving them. You can't rush to the eviction courthouse without complying with the rules. Hi, my name is Rob Wells. I'm the Landlord War on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I was just getting ready to go work out, and I was dealing with a landlord email, and it was one of those, Rob, I got a 3-day notice. How quickly can we go to court? I go, okay, let's, shouldn't be too long. A lot of places now e-file. Look at the 3-day notice, and this landlord made the rookie mistake of not including their name, telephone number, and address where rent could be paid. And then in this case, they also failed to indicate that the usual days and hours where rent could be paid in person, because the address allows for personal delivery of the rent. Landlords, I gotta just tell you, the rules per the Code of Civil Procedure, particular section 1161, subdivision 2 of the Code of Civil Procedure for rent cases, the rules are pretty stringent. Okay, you have to follow the rules each and every time. In this case, this landlord used a form, notice to pay rent or quit. The notice had all this stuff in there. The problem is the landlord didn't fill it out properly. Just skip the whole section about where to pay rent to, where the name of the landlord, their address, and their telephone number was completely omitted, and they didn't fill out the usual days and hours. And I have to tell the landlord, I'm sorry, landlord. You served this notice last week. Well, you're going to have to do it again because it doesn't have all the things I need to go to eviction court on. And this case will get thrown out. It's, tenants' attorneys, the attorneys that do this every day, their eyes are trained. They got worksheets. They got spreadsheets that check this here, check that there. If you didn't do that stuff and your notice is missing, guess what happens? By law, you don't have a cause of action for unlawful detainer. Meaning, in English, you don't have grounds to evict a tenant because you have to comply with all the things required in the Code of Civil Procedure. Your notice has to be served properly. It has to have all the things required under the law before you can evict someone. And if you're missing that stuff and you don't know what it is, you got to educate yourself and doing notices the right way. Because if not, your attorney's going to tell you, guess what? It's missing this, start over, do it again, and let's get everything on file. So I got it. My mentor always tells me, be quick, but don't hurry. I tell landlords the same thing now. Be quick, don't hurry. Landlords, if you're facing a non-payment of rent situation and you're in the Northern California area and you need some help, reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.